A jury has found a Wisconsin judge guilty of felony obstruction after she allegedly helped a Mexican immigrant evade federal immigration agents at her courthouse. It was a split verdict, though, and jurors found Hannah Dugan not guilty of a lesser misdemeanor concealment charge. The judge is facing 5 years in prison. A sentencing date has not been set.
We are starting with breaking news here. A federal judge has denied former Milwaukee County Judge Hannah Dugan's request for an acquittal.
Hannah Dugan is back, and the news is not good for her. The Milwaukee judge who walked the illegal immigrant out the back door of her courtroom to dodge ICE, her team went back to the judge and asked him to erase the entire thing, and obviously it did not go well for her. Let's get into it.
A federal judge has denied former Milwaukee County Judge Hannah Dugan's request for an acquittal. Now, in December, a jury found Dugan guilty of the obstructing a proceeding before a U.S. governmental agency felony charge.
We had a hearing, we had sentencing that was scheduled, and that did not occur because the judge wanted to hear her new arguments. And now she loses. Judge writing, Hannah Dugan, the backdoor judge, moves for reconsideration of the order denying her judgment of acquittal or granting her a new trial.
So this happened about a few days ago. I didn't get a chance to talk about it, so here it is right now. And for those who may not know, this is the update for everybody who watched the video maybe a few months ago on this situation. We told you that the appeal was coming, and before that appeal, her team tried one more time. At the trial level, they asked the judge to throw the whole thing out and declare her not guilty. That was denied, obviously. A jury already convicted her of the felony back in December, and now the judge looked at it a second time and said that the conviction stands. And let's be clear what a acquittal motion actually is. It's the defense saying, forget the 12 people who sat through the entire trial, listened to all the testimony, and said, Your Honor, you overruled all of them. That's a heavy lift in any courtroom, and the judge said, no, the verdict that the jury handed down is still the verdict. She is still a convicted felon, and nothing about what happened the other day changed that.
This case isn't over yet. I think it's important to say that. You can expect that the Dugan defense team is going to appeal this case. And this is now the second time that federal Judge Lynn Adelman ruled against Dugan. Twice her team has asked the judge to overrule the jury. At the beginning of June, he heard oral arguments on Dugan's second request.
The second time, let that sit. In the last video we talked about, we walked through that 49-page order where the alderman shot down her motion to toss the conviction or get a new trial. That was round one. This is round two. The same judge, same argument, same result. Denied again. I mean, I have to respect the hustle of a defense team. That's their job. You need to throw everything at the wall. You need to try to do whatever it takes to get your client off. But at some point, the pattern must tell you something. When one judge looks at your case twice and rules against you both times, that's not really bad luck. That's the evidence. They keep asking the same man to undo the work of the jury, and the man keeps coming back and saying that the jury got it right. You don't get a do-over just because you didn't like the score. The referee already blew the whistle twice now. But real quick, if you like this type of content, hit subscribe so you don't miss any more of this, especially the sentencing that's going to probably come through. This situation is still not over, and you know we're going to be here for that update. Let's get back into it.
In April, a U.S. appeals court in Virginia ruled that obstructing an ICE arrest warrant does not constitute interfering with a federal proceeding. So Dugan's team asked the federal judge to throw out the guilty verdict and rule she is not guilty. Prosecutors argued other cases back up the conviction, and they argued that the appeals court case does not apply to the Dugan case.
She noted that ICE goes out every day to try to arrest people. Given the fact that there are 10 million undocumented people here, does that mean that there are 10 million pending proceedings? There should be. She insists that there needs to be some formality, like it needs to be in front of an agency, like it's only a proceeding if you're standing there in front of a judge.
Now, this is the actual argument that brought this time, and it's really clever. I'll give him that. A different appeals court all the way over in Virginia ruled that messing with an ICE arrest isn't the same as interfering with a federal proceeding. The whole case hinges on one word. So Dugan's team runs to alderman and says, see, another court agrees with us. Toss away the verdict. But here's the problem. That Virginia ruling isn't binding in Wisconsin. It's a different part of the country, a different circuit. So her team essentially asked a Wisconsin judge to follow a decision that he doesn't have to follow. In order to free a defendant he already watched get convicted. It was a big swing, but borrowing a ruling from another circuit and hoping it sticks is not the same as having the law on your side.
Prosecutors argued other cases back up the conviction, And they argued that the appeals court case does not apply to the Dugan case. So here's what Judge Lynn Adelman writes in his decision. I'm going to quote here. In sum, that other case, majority opinion, provides no persuasive justification for excluding the ICE proceedings at issue in this case, cannot be reconciled with the plain language of the statute.
Court decisions going back at least 6 decades say it's broad. And turning to this case, Congress envisioned a proceeding as a continuing sequence of investigation, adjudication, and enforcement, and it encompasses all of the steps that we just reviewed.
This is Alderman's answer in his own words. He read the Virginia case and said it gives him no persuasive justification to apply here. So the translation, nice try, doesn't work. He's saying that you can't read another ruling so broadly that it wipes out every ICE enforcement action, no matter what stage it's at, because that would crash straight into the plain language of the law Congress already wrote. That's the whole ballgame right there. The statute says what it says. A judge in another state's opinion doesn't rewrite the words on a page. This is the part that people miss about the law. It's not about which ruling you like better. It's about what the statute actually says. Alderman read the text, read the other case, and found that they don't conflict the way her team needed them to. The plain language wins, and the verdict stands.
It's almost assured that Dugan's defense team is going to appeal this. That would be a different circuit court of appeals, the 7th Circuit, which is based in Chicago. So if they rule against Dugan, this potentially could set up a circuit split, meaning this case could end up all the way to the United States Supreme Court.
Problem for the defense is that this case did not involve some random encounter. This was a targeted operation conducted pursuant to agency procedures, including the issuance of an arrest warrant for one specific person, Eduardo. After the arrest, ICE followed its procedures for reinstatement of the order of removal. While this did not involve a contested hearing in front of a judge, that is because Flores didn't go in front of the judge.
So where does it go now? Goes up. Her team is going to appeal. The reporter said it's almost guaranteed, and this time it goes all the way to the 7th Circuit in Chicago. And here's where this gets interesting. You've got Virginia's court saying one thing, and if Chicago's court agrees with Alderman, now you got 2 appeals courts pointing in the opposite directions. And that is called a circuit split. And when the circuit splits, that's exactly the kind of disagreement that the Supreme Court exists to settle. So yeah, this courthouse backdoor move in Milwaukee could generally end up in front of 9 justices in Washington. Meanwhile, she still hasn't been sentenced because every one of these appeals freezes the clock. More than a year past the events that started all this, and we're still waiting on the final word. So this is far from over. But let me tell you what this case is really about, because it's bigger than just one case in Milwaukee. When you put on that robe, you're giving something up. You give up the right to do whatever you feel like. You become the referee, the neutral party, the person in the room that's supposed to follow the rule book even if you personally hate the call. That's the job. That's the entire job. Hannah Dugan decided her personal feelings about immigration law were more important than the law that she swore to uphold. She looked at the federal agents doing their job, decided that she knew better, and walked the defendant out of the side door. That's not judging. That's picking a team. And here's the thing. It doesn't matter which side of the politics you're on. If a conservative judge snuck someone out of the back door to dodge a warrant that they didn't like, I'll be saying the same thing. The law isn't yours to bend over because you won an election or your politics point a certain way. You don't get to decide which laws are real today. The referee doesn't get to play for a team. Alderman said it twice now, and we'll see if the next court agrees. Let me know what you guys think about this story in the comments below. And if you haven't subscribed, hit that subscribe button. Thank you for taking time to watch the video, and I'll see you guys in the next video.